The committee will be in order. Good afternoon. Welcome to the Joint Standing Committee on Veterans and Legal Affairs. Today we have language reviews, which we will get to after we have introductions. We'll start today on my left with Representative Mouse.
Good afternoon. I'm Mark Mallon. I represent House District 133, part of the great city of Biddeford.
Sean Faircloth, Representative, House District 24.
Good afternoon, everyone. My name is Ann Fredericks. I represent House District 143, Sanford.
Representative Graham.
Good afternoon, I'm Representative Annie Graham. I serve the people of North Yarmouth and the majority of Gray, House District 105.
Good afternoon, I'm Parnell Terry and I represent District 108 in Gorham.
Hello, everyone. I'm Sharon Frost. I represent District 58, which are the 6 lovely towns of Belgrade, Rome, Mount Vernon, Vienna, Fayette, and New Sharon.
Quentin Chapman, District 88, serving the fine people of Auburn, Maine.
I am Senator Jill Doosan. I represent Senate District 27, which is part of Portland and part of Westbrook.
Good afternoon. I'm David Boyer. I represent District 87, which is the individuals of Poland and Mechanic Falls.
Madam Chair.
Hello, my name is Laura Supika. I represent District 22, which is a portion of Bangor.
And I'm Craig Hickman. I represent District 14, 12 municipalities in Southern Kennebec County. Here in the Maine Senate, we have Michelle Hebert with us, our committee clerk, and our analyst, Ms. Rachel Olson, to show us all of her great work today. It looks like we have 3 bills that are just about ready to be reported out.
Yes, we'll start with 1609.
1609, 1851, and 1488, and then we will have preliminary language review on 1847. So with that, Ms. Olson, the floor is yours.
Okay, LD 1609, an act to prevent the participation of individuals and companies linked to federally recognized criminal organizations in the medical and adult use cannabis programs, which is retitled an act regarding background checks for medical cannabis providers. It is ready to be reported out, or it's ready to be finalized and reported out in this case. So you have the final language on pink. This is the same as the language that was previously shared with you. And then the fiscal note for that has come in. That's on green. Indicates a minor cost increase to the general fund, revenue increase to the general fund, and revenue increase to other special revenue funds, which are expected to be minor and absorbed within existing budgeted resources. And any increase in revenue is also expected to be minor. So that will be incorporated into the amendment, and then it will be ready to be reported out.
Thank you, Ms. Olson. Are there any questions, concerns, or objections? Seeing none, we will report this bill out. Thank you.
Moving on, we have 1851. This is an act to bring parity among the Wabanaki nations regarding the generation of revenues from gaming. This is a minority report. The language you have seen previously, and the fiscal note has come in. This will also be incorporated, and then it will be ready to be reported out. As you can see, that the bill reduces the share of gross slot machine revenue deposited to the general fund from 1% to half of 1%, and directs the remaining half to the Holton Band of Maliseet Indians and the Mi'kmaq Nation. And the bill also provides that if either tribal government receives revenue from internet gaming, that portion of the 0.5% attributable to that government reverts to the general fund. And so you can see the cost to the general fund of $3,179,647. There's a corresponding allocation for other special revenue funds because it's shifting that money from the general fund to other special revenue funds. If both tribal governments receive internet gaming revenue, the general fund revenue reduction will be partially or fully offset as it's redirected back to the general fund. But because the regulatory framework for internet gaming has not been finalized, the fiscal impact of this provision could not be determined at this time. So you can't really put the two together. And then you can see the AA section on the back. So as I said, the fiscal note will be incorporated, and then this will be ready to be reported out for those of you who are on this report.
We're good to go? Thank you. This can be reported out when it's ready.
And then I have a fiscal note to share with you, not language, just the fiscal note for 1488 came in. But in an attempt to get everything in front of you when we're meeting in person, I've made a copy and shared it with you. LD 1488 is a unanimous report of the committee. It will also be an emergency. This is an act regarding cannabis testing and the manufacture of cannabis and hemp products. The fiscal note is a minor cost increase to other special revenue funds, which is minor and can be absorbed within existing budgeted resources, which I believe is what the sponsor had indicated at the time the committee took the vote.
Yes, thank you for that. This can be reported out then as soon as the
Well, yes.
final
well,
language is ready.
We can and should discuss how we'll conduct language review moving forward.
Okay,
After this week, we don't have to do that quite at this time. But I would imagine that this will either be before you the next time we meet or will be reviewed via email
okay. Thank you.
or at your seats.
Great. Thank you for that fiscal note.
And that is the final language and fiscal notes that I had for you today. And then scheduled for today was to bring back the draft language. It's not initial language, it's just draft language
Okay,
for the 3 amendments to 1847 that the committee voted on last month. I'm going to have Michelle hand them out before we get started, all of them. I do have some questions
Mhm.
after having drafted them and a couple of things I would like to point out
okay,
before we move too much further down the process.
perfect. Thank you. In advance, it's clear that that was a lot of work.
While Michelle's handing them. I just wanted to say while Michelle's handing them out, I tried to keep the colors to the
I
to
was
the
gonna
same
ask that
colors as
question.
before for the sake of clarity. And
Thank you.
there are 3 of them.
No, this is-
And at the very top, you're
Oh.
going to see whether it's the majority or minority report and the person who made the motion that's attributable to that report. There is an LR item and number, which you probably don't pay that much attention to. It's mostly for internal processing. I did keep it on there so you can see 2, 3, 4. 1 is always the original bill. But I put the label at the top.
Chair recognizes Representative Fredericks.
Thank you, Mr. Chair. What was the final vote?
I don't actually know. I think it was 6511.
I have it for you.
6511.
Thank you.
So 6 members voted in favor of the majority report, which is the one that you've just received. 5 members voted in favor of the first of the 2 minority reports. That's the yellow one coming around, butter yellow, if you'd like. 1 member voted in favor of the other minority report, which will come around on buff in a moment, and 1 member voted ought not to pass.
Thank you.
Mr. Chair.
Chair recognizes Representative Boyer.
If you were to give a color to ought not to pass, what would it be?
Red.
And can we just get like size 18 font, one, keep everything in order? Red.
Don't have red paper.
Green. Keep it green. Okay, I think we all have the 3 reports. No, not yet? Oh, okay, no, duh. Now we all have all three reports. Ms. Olson, you may begin in whichever order you prefer.
Okay, we'll begin with the majority report. This should look relatively similar to the language that was voted on at the time of the vote, with a few notable exceptions, largely because of added information. True for all of them. I did adjust the definition of cannabis pre-roll to remove the language regarding packaging, and added and intended for smoking. And that's true across all three reports. And this is the definition that's referred to in Title 36 regarding the excise tax as well. I will note, of course, that I mentioned this, I believe, at the time that we considered it. There is a provision also regarding excise tax and cannabis pre-rolls that is included in a bill in the tax committee as well. That is, I believe it's going to use a similar or the same definition, but it approaches the excise tax differently. If you turn to page 3 of the majority report, section, and I just want to start out by saying a couple of broad things. Number one, all the section numbers may not be in numerical order, and they might be duplicative or missing. As we finalize them, those will all get corrected. So you might see like 2 section A8s, for example, or be missing a 17. So just, that's fine. And the titles will inevitably, I'm sure, change as the revising office will give me some great advice on better titling. But I did take a stab at all of them. As you know, the bills do many things and the title can't quite say it all, but does need to be descriptive. So section A15 on page 3, this is section 2423G, testing program established. This was one sort of large paragraph previously. It's been chopped up, but substantively it did not change. This chopping is true for all 3 reports that have it. And then I believe that that is the only significant change in part A of the bill that I wanted to flag. And then for part C, shouldn't really be any changes in part from what we, the use of the fund was one change. The money for research, yes.
The chair recognizes Representative Graham.
What page, please?
19. Yes, but actually, if you look on 18, the amendment had asked to move the provision regarding research on public health impacts for cannabis use for individuals under 21 years of age to the adult use, public health and safety and municipal opt-in fund. And so you can see that language on page 18, currently as paragraph B1. I did want to note, though, because we didn't talk about this at the time, that the way that this paragraph subsection, is structured, is that if you look on page 19 in paragraph D, we've talked about this in previous sessions, but D says any funds remaining in the fund after expenditures made in accordance with paragraphs A to C2. So everything above paragraph D. So though would be used for the purposes of subparagraphs 1 and 2 of paragraph D. We didn't necessarily discuss in what priority you wanted to give this funding. And so I included it in the same way that other changes using this money have been done, such as the social equity program and the cannabis business advocate, for example. So I just wanted to point that out, that it's been placed above that. So it is one of the, you must use the money for A, B, B1, C, C1, and C2, and then any leftover funds are used for paragraph D, 1 and 2.
Yep, thank you.
On page 19, and it ends at the bottom of page 19, part C is just those two, C1 and C2, is my attempt at the language for the excise tax on a cannabis pre-roll. So beginning January 1, 2027, a cultivation facility licensee shall pay an excise tax pursuant to subsection 1 or subsection 2, based upon the amount per pound or fraction thereof of cannabis flower or cannabis trim contained within the cannabis pre-roll. I have not had this language reviewed by anyone at MRS, but I think it's workable,
Yep.
and is modern. And then I will say that I frequently get some very nice advice from the revisor's office about drafting unallocated language. It's not always my forte, but you have my attempts on page 20, part D. So D1 are monthly reports on inventory tracking system contract performance. Section D2 is the competitive bidding process. I phrase this as the office shall begin the competitive bidding process by August 1, 2026. Although I may need to adjust that because the effective date of the act is January 1 of 2027. And so to the extent that you want the unallocated language to take effect before the allocated language, we might need to adjust the effective date to allow for that. Does that make sense?
Chair recognizes Representative Mallon.
Thank you, Mr. Chair. Can you elaborate on that a little bit? Like, what would we have to do to the effective date?
Oh, I mean, as long as you want to stick with the dates in part D,
Yeah,
I think, and I'm not sure exactly the language, but you can essentially say the effective dates of part A, B, and C are this, and the effective date of part D or of section D1 or D2
okay.
and D4 are effective on this date.
Okay, I
or
approve
take
you,
effect
I approve you
immediately.
doing
So
that. 'cause
as
I
long as
would-
you want to keep the dates that are here,
Yeah.
that's just me making sure that it's technically correct.
Okay, I approve of you doing whatever you need to do. It is my intent, and I believe the intent of everyone who voted for this, that the competitive bidding process would start before everything else.
I have a question about D1 for Representative Mallon. Is there a reason why that's unallocated language instead of statutory language that would be a part of the section that covers the inventory tracking system in Title 28B?
I think the biggest reason, Mr. Chair, would just be that we're directing them to get a report, to send us the report that they are receiving under the contract already. I'm not sure if that report itself is part of the statutory, that their receipts of that report from the entity which won the bid is part of the statutory language. So I thought it was cleaner just to have it be a direction to the department rather than something that is in statute. Seemed to be the cleaner way to do it.
Asked and answered. I'm just curious. Thank you. Ms. Olson, you may proceed whenever you are ready.
Section D3 is directing the Office of Cannabis Policy and the Office of Information Technology by March 1st of 2027 to provide or report to the Joint Standing Committee of the Legislature jurisdiction over cannabis matters an estimated cost for the development and maintenance of an electronic inventory tracking system for cannabis that would be developed and maintained by the state. And that meets the requirements outlined in statute and in rule for both the main medical use of cannabis program and the adult use cannabis program, which I realize are probably not the correct titles to those, but get the intent across today. The estimate should include information on the functionality of such an inventory tracking system and an estimated timeline for implementation, as well as an estimated total cost for development and for ongoing implementation and maintenance costs. I think that captures what you were looking for. And then D4 is directing OCP to implement a program for registrants with a gross annual revenue from medical use cannabis operations of less than $125,000. If those registrants' total testing costs for that year exceed 10% of their gross annual revenue. And the program shall include payments to the registrant of $100 per batch tested, paid for using funds from the main medical use of cannabis fund. Sound okay?
Chair recognizes Representative Boyer.
Thank you, Mr. Chair. I wanted to back off from the $100 coupon and just go back to D3. Could help me understand that, I thought this bill and this tracking system is regarding medical. And while there's a lot of copy and paste from the adult use and for those regimes, I do believe we made like an exemption regarding batch versus room for medical. We talked about how it's doesn't make sense that you'd have to do 4 tests for 1 room if you had 4 different strains. Maybe I'm remembering the conversation that we did have around it, but I thought the majority was comfortable with doing tests by room rather than by strain. So that's not how it is with adult use now, is my understanding. So having a portal that meets the requirements outlined in statute and rule for both the medical and adult use program. So are we asking them to do a new RFP for a tracking system that would do both and a new contract for both programs?
So section D3 is asking OCP and the Office of Information Technology to develop an estimate. Essentially, you're asking them, could you build this program, this tracking program
This is
for
for
us?
the so-called
And how
portal.
much would it cost? It's not the RFP.
Gotcha. Thank you.
That's D2.
And in regards to D4, I'm wondering, and I know this is just a draft of the bill, but I guess I'm wondering why this program would be unallocated language instead of statutory. Because it would seem to me that this is a program that should be seen when the reader looks at the law, and the provisions of this, I suppose, will be developed in rule, but it doesn't say that here. And I'm wondering if we could just talk about that a little bit more. Representative Mallon.
Thank you, Mr. Chair. I think unallocated language is the place to do that because we're asking them to design this program. It does not currently exist, and statute, I think it would be too messy in statute to have a program to have the this direction, I should say. If in the future it looks like statutory adjustments are needed, I'm willing to entertain that. But I think we're telling them to get started with setting this up. In terms of people actually seeing that the program exists, I would hope, and I would be happy to amend if necessary, that they would be putting information about this on their website and any other materials they have so that registrants know that this exists. But I do not believe it belongs in statute.
The chair recognizes Representative Boyer.
Thank you, Mr. Chair. This is for our analyst. Is there anything in D4 that ties in with the implementation of this? I feel like, call me a cynic, but this gets off the ground and then the program for the those that are a hardship for the testing regime, it could be a year or 2 before these coupons are up and running, and that might be too late for these small businesses that have told us that they're going to go out of business. So I don't, is there anything that ties timing together?
There is no date set in D4 regarding when the Office of Cannabis Policy should implement the program. I actually would say that it is possible to put it into statute. And so it is possible. I don't know if you have to do that. You could add in the mandatory testing section for medical on page 10 and 11, possibly add like a subsection 10. That would just direct the Office of Cannabis Policy to establish a program to provide financial support to these registrants who meet the criteria. And that support has to be at a minimum $100 per batch tested. And the funds come from the Maine Medical. I think you could do that. Certainly, there is a difference between putting it in statute and putting it in unallocated language. You are directed them to establish a program if you want that to get up and running. And I'm going to talk about this in our other bills. As outlined in this majority report, the rulemaking is specifically routine technical for the programs that are being established in this report, which would allow for the office to begin development of those rules using the APA process, and does not require legislative approval for those rules to get up and going, so that it is more likely that they could get this program that you're referring to in D4 established concurrently with the other rulemaking that would occur for the programs outlined in the bill. You could also stick a date in here if you wanted to leave it as unallocated language. You could also, like in D1, D2, and D3, you could establish a date for that program. Again, I don't want to go down the rabbit hole of talking about unallocated language and statutory, but unallocated language does have the force of law, but we know that sometimes there are other obstacles to that.
The chair recognizes Representative Mallon.
Thank you, Mr. Chair. Question for you, Ms. Olson. If we were to put it in statute, which I am amenable to, or to put in an effective date in D4 itself, if we kept it as unallocated, would that be something you could just do with our direction, or would that require reconsideration? Or
That's just this is a technical choice
Yeah.
really to move it, that nothing changes substantively about what the bill is directing.
I would like to put D4 into statute and have in that way, if we did it that way, the date for that would match the effective date of the act. That's what I would like to do.
Okay, and if I am going to run this is something that I would probably discuss more internally, and whether there's any reason why it couldn't be allocated language. If it were for any reason be decided to stay unallocated, I'll just add the effective date of January 1, 2027 to that language.
That is what I would like. Thank you.
So, the chair recognizes Representative Graham.
I just wanted to state, Representative Allen, I agree with his comments, and that the intent of this D4 was to provide assistance as soon as possible. So whatever way we can get that done, either through allocated language or statute, that's what I would support.
So I appreciate the conversation about this, because it clearly is, I believe it was Representative Frost's impetus that this is here. I'm wondering though, Ms. Olson, if this language is prescriptive enough for rulemaking purposes, because it just seems so open-ended. I don't know how this would be administered. Do we need to direct the agency to do something more than just develop a program, or do we need to put some parameters around the program outside of who qualifies? Meaning, at what point does the $100 get to a person per batch? Is it in 90 days? Is it in 30 days? Is it in 20 days? Is it a year from? I don't actually know how this program would work, and I'm wondering if we need to talk about that a little bit more as a committee. Representative Mallon, did you have any ideas on that?
My belief in looking at this is that this is prescriptive enough for rulemaking. We talk about, we contemplate who would qualify, and how, what the amount would be. Obviously, we're exploring moving it into statutory language. We have a backup plan for the effective date. If not, I don't think anything more prescriptive needs to be fleshed out in this.
And I will say that I also think the language here is enough. If the members of this report wanted to be more prescriptive, you always have that option as the legislature to be more prescriptive about what you want those rules to be. But it would be through rulemaking that those elements that you are discussing would be addressed. The rulemaking process includes public comment, and so the office could receive feedback about the timing for what the best timing would be for those types of payments
Okay.
through that process.
I would like to ask the agency a question about this. Ms. Gabby Fairby Pierce, please.
Hello, I'm Gabby Bearby Pierce. I'm the Policy Director for the Office of Cannabis Policy. How can I help you?
Thank you for being here. Is there any other currently, does the Office of Cannabis Policy have any reason to know the annual gross revenue of a registrant?
No,
And were you to write these rules, would you have to then take the registrant word for it, or would you try to cross-reference this information with Maine Revenue Services? Is that allowed? I'm just trying to understand how this would be implemented and enforced.
it is my expectation that much like the municipal reimbursement plan program that was implemented a few years ago, that we would ask for the applicant to provide proof sufficient to demonstrate their gross revenues and the costs associated with testing.
Fair enough. Thank you. Ms. Olson?
I think those are all the points for this one that I wanted to discuss. I just will say that obviously for all three of these, they are not small. And I understand you may want additional time to review them. And so that is why they're here before you as drafts. And that it is, if or when I'm directed by the committee, we can discuss these further. It is also the end of session and we are unlikely to have many more meetings in person. So I want everyone to just be aware of that fact.
We can request to meet in person if we need to, not that we'll get approval. But we could request from the presiding officers to meet in person to discuss these more if we had to. Is that correct?
That is correct.
Okay, thank you. Chair recognizes Representative Fredericks.
Thank you, Mr. Chair. Just a question about the amendment 2A. Two questions. So
Sorry, can you?
page 19 of the majority report. It's in regards to the excise tax on the cannabis pre-rolls. So my first question is, had we discussed excise tax on the cannabis pre-roll in the bill?
It was brought up during the work session, the last works, well, I think it was brought up more than once, but at the final work session, it was brought up, and Senator Hickman distributed an email from an individual who expressed an interest in this type of breakdown. This is not a new issue for the committee. It's come before this committee in the past as well. And as I noted, obviously tax is also discussing this issue currently.
You may proceed.
Thank you, Mr. Chair. Thank you, Ms. Olson. Am I correct in the amendment that's being proposed? It's adding an excise tax to medical cannabis on top of the sales tax of the pre-roll?
No, it's not it's not adding another sales tax on top, or excuse me, excise tax on top. My understanding of what it is doing is trying to clarify for the purpose of excise tax, how cannabis pre-rolls should be taxed. Currently, Maine Revenue Service is taxing cannabis pre-rolls at the rate for cannabis flower. Even though it's been reported by members of the industry that cannabis pre-rolls may contain cannabis flower and cannabis trim. And cannabis trim is taxed at a lower rate. for excise tax than flour. And so this would be, according to those who supported the report, a more equitable excise tax framework.
And in that conversation, in the letter, email, communication to the committee, the client of the lawyer said that the pre-rolls that his client creates are 100% trim, taxed at 100% flour for the purposes of the excise tax. And so it's a really big difference in the amount of money that the Maine Revenue Service believes this entity owes them because of that purpose. You may proceed.
So still I'm unclear, Ms. Olson or the chair. Will the end result be an excise tax and a sales tax for the
It-
pre-roll?
So
But no, I'm concerned about the medical program. Okay, so this is,
there is
Thank
no
you.
excise tax
Sorry.
in the medical
Thank you.
program.
Oh, sorry, yes.
that's what I was very
And-
confused about,
Yeah.
because I thought we're talking about the medical
No.
program and testing, and then I see the excise.
Sorry, no, part C is specific to adult use.
Thank you very
Sorry.
much. Yeah.
No worries. Chair recognizes Representative Mallon.
Thank you, Mr. Chair. And for folks who recall that lawn meeting we had while I was in the middle of my 30-minute lawn motion about to pass as amended, the chair asked me about this particular provision, and I agreed to include it in response to the concerns that he raised. And there are, obviously, as mentioned by Ms. Olson and others, there are some changes to adult use in this bill. Obviously, it's not only changes to the medical program. There's adjustments made and things along those lines, even though medical is the biggest focus of the bill.
Chair recognizes Representative Boyer.
Thank you, Mr. Chair. Just wondering, I see the pre-roll change, that would obviously cost the state revenue. The program for the lab coupons, that would take some labor for the office. Do we have an ETA on fiscal notes for any of these three?
This bill
Drafts.
has not been processed, so until these drafts have been submitted to the revisor's office and shared with the office of the OFPR, we won't get a fiscal note. So until that, your official reports need to be put into processing before they can even begin their work on a fiscal note.
I understand the process is the process, and I just would, it's unfortunate that we're voting, without seeing the cost of these bills. I know it's not exclusive to this committee or these bills, but coming from a process place, it'd be nice if we had that information before it got out of committee. Thank you.
Any other questions on the majority report from those who are on the majority report or for those who are not? Chair recognizes Representative Fredericks.
Thank you, Mr. Chair. I don't have location in this amendment, but Representative Boyer had raised the question about batch testing versus Nancy, great.
Chair recognizes Representative Mallon.
Thank you. That the batch by room issue that was raised by Representative Boyer is not in this. It was not part of my motion. It was something that was discussed informally at various points, but it was not part of what we voted on.
That is correct. Okay, we will move on to the other two. We'll take,
Okay, we'll move to the minority report on butter yellow, the Hickman report. Before I get to my two questions, I would like to point out that this had a significant drafting revision. And you can find that on a couple of different pages. So first, page 8 through 10. Section A21, which is section 2430J. This section is repealing the current section regarding record keeping and replacing it with the language here. This is the records, inventory, tracking, and labels section. The label section is unchanged from current law, but because of the restructuring, I chose to repeal and replace. So we were provided language regarding tracking, inventory tracking in the sponsors amendment, and I have reworked it. But it would be, and I understand that it's not something that probably can happen today, but those of you who are on the report should carefully examine the new language to make sure that it does not deviate from the intent. I did combine a couple of things together to try to bring clarity to the section and try to bring in appropriate language. But I do ask that those who supported this amendment and who worked on the language that was submitted to the committee carefully examine the changes, particularly in subsections 2, 3, 4, and I think 5.
Yes. You certainly will. Thank you.
Additionally, if you were to turn to page 14, going all the way to 16, as was proposed in the amendment at the time of the vote, this amendment establishes an audit testing program. But the audit testing program in the draft that was shared had it kind of in two places, the establishment of the audit testing program. But then it was included in a different section of statute regarding registration violations, the sort of process and penalties as you might have moved through the audit testing program after receiving a failing test. And so in drafting, it didn't make as much sense to do it in the way that it was drafted. And so I combined the two provisions into this new section, which begins on the bottom of page 14, establishing section 2430S, the audit testing program. And it lays out the criteria for getting into the program. So requesting a determination of audit testing program eligibility, what you need to do to be eligible in subsection 2, that the office will determine your eligibility and notify the registrant in writing, that you're exempt from mandatory testing once you're in the program. And then subsection 5 and 6 bring in we were calling it sort of the penalty ladder for testing and how you kind of go in and out of the program. And so that language is reworked here. So again, I would ask that that's carefully examined by those on the report. And because of that change, if you remember, if I'm going in the right direction, you look at pages 6, 7, and the very top of 8. This is the registration violation types, section 2430I of current law. The change on page 6 was requested in the amendment, but you'll note that I've also made changes on pages 7. This is, on page 6 in subsection 6.
Yeah.
So these paragraph A is major registration violation affecting public safety. So the language that was in the amendment is 4A, intentionally or knowingly failing to conduct a recall of harvested cannabis or cannabis products when required to do so by the office. And then added in subsection 7 or subparagraph 6. I don't know where I got 7 from. This is a kind of a catch-all, other intentional or knowing egregious conduct that imminently threatens public health and safety, or conduct that shows a willful or reckless disregard for public health and safety that poses an imminent risk to public health and safety. And I added including failing audit testing under section 2430S subsection 6 paragraph C, which is the sort of end of your testing, meaning you failed numerous audit tests. Paragraph B is a major registration violation. And so added in subparagraph 9A is failing an audit test under 2430S subsection 6 paragraph B. And then a minor registration violation is C. And that carries over to the top of page 8, where is your first failure of an audit test, which is paragraph A of subsection 6 and 2430S. And those correspond to those paragraphs in the newly established program. And if you look at that program, what you'll see though is that the language is may be subject to these penalties. It's not that you will be or must be, but that you may be subject to those. And then I needed to add that corresponding language in that section regarding the violations.
So, I'm not, I think I understand this and I'll have to review it a little bit
Yes.
more for sure. I'm not sure that the first change you mentioned in subparagraph 6 is necessary, but I'll review it just to test my own thought on that. Chair recognizes Representative Boyer.
Thank you, Mr. Chair. That was kind of my question. I guess I see it under, major registration regarding public safety, and then a major registration that doesn't affect public safety. When does it go in one or the other, I guess, for failing an audit test?
So upon your first notice of a failed test, you might be subject to the minor registration violation,
Okay,
paragraph C.
Yep.
If you turn to page 16, if additional audit testing results in a failed test, then you may be subject to a major registration violation. And then if further audit testing results in failures, then you may be subject to a major registration violation affecting public safety. So with each continued failure, you climb the violation ladder.
Got it.
and I guess where would it fit if the operator kind of put forward material that they knew failed, but that were exempt from having to test because they were on audit testing? Does that make sense?
I don't understand.
You could be on audit testing, you're good. And maybe you continue to be on audit testing, but you still get test results to the contrary to the limits, but don't tell anybody and don't do anything about it. Is that covered under one of the, existing violations?
So the
yes.
registrant is conducting other testing on their own behalf.
Yes. So like,
I mean,
I think
they're,
knowingly selling
oh,
cannabis.
there is language, so I think that, well, I'm not the office. It's possible that doing that, would have you fall under that major registration violation affecting public safety in that catch-all number 6.
Right.
Intentionally or knowingly doing something
As
egregious.
it should.
So I think that's where that would.
Thank you.
Would land you. Yeah, sorry. Now that I
I see the
understand.
office is sort of not in agreement with all of this for anyone who is not in the room, but I think it's covered as well.
So those are the big significant changes. Now, you did remove some of the language from B. So that the adult use provisions. So this section B is shorter than in the others.
Mhm.
You have the same language in part C for excise tax.
Mhm.
And then before we do part D, I have two big overall questions.
Okay.
The first question has to do with the audit testing program. And as the committee knows, registrants do have the ability to remediate harvested cannabis that may have failed a test. But there's no mention of the registrant's ability to remediate harvested cannabis during the audit process.
Okay.
So if I've failed an audit test as a part of being a participant in the program, can I remediate it? I don't know if you can remediate every contaminant out, so I'm not sure if it's applicable in every situation, but there's no mention of remediation, and you are allowed if you are looking at page 16 in particular, this is where I flagged the question for myself. A registrant's allowed to retest a failed batch. So if the office is conducting the audit test and that batch is failed, the registrant has an opportunity to essentially challenge that failure by retesting it. Is there any, so what happens with remediation here? How does remediation fit into the audit testing program? It does also allow the registrant at any point in the process to voluntarily surrender
Mhm.
any harvested cannabis to the office. But remediation was sort of left out of this framework.
We'll definitely take a look at it, but Chair recognizes Representative Boyer for
On-
a preliminary answer.
I think it should mirror what's allowed in adult use. And so that would mean that remediation is allowed after a failed test. And there's different ways you can remediate it. And I think including making oil and concentrate from it. And I would imagine the office has like a table of acceptable things at different level. If you fail for this thing, then you can do X. If you fail for Y, then you can't do. So I would just either direct or however, just that it should mirror how it's treated for adult use.
I'm not sure I agree with that. I think that we need to take this under advisement and answer your question when I understand the intent of this section from the people who helped to write it. So we'll have to get back to you on that question, which I have now flagged.
And I will say, I mean, from my drafting perspective, the reason that I thought this mostly, especially, and it may apply in other situations, is particularly when a registrant has the ability to challenge a test result from the office. Can they essentially subvert that by remediating it and then resubmitting it? Because as it is supposed to be a sample from the same batch of harvested cannabis that failed testing within that same matrix. So really nothing is meant to change.
Right.
And it's not clear that remediation would be allowed or prohibited in that section. And then I think there's the bigger question too about just maybe where or how remediation might fit. So because maybe you failed an audit test and we're not talking about the challenge test, but we're saying, okay, so I go remediate that batch and it's getting the additional up to 6 additional, that might be too far, my thing might be. Yeah, it's now being tested up to 6 times more. Could I have remediated in there to then pass my next audit test? And I think it's important to think how remediation fits into what is the proposed framework of audit testing, which is not the same as mandatory testing. And so that is a question that I have for you.
That is correct.
Those of you who are on the report, that question will also be asked of Representative Supika's amendment as well.
Mhm.
And then my other question for the members on this report have to do with timing. So you've already brought up timing, just as that's always a question. This amendment does not have an effective date, meaning that it would take effect 90 days after enactment. But all of the rulemaking is major substantive, which means that anything that requires rulemaking to get the program started could not begin until rules had been developed, submitted to the legislature, and approved by the legislature. And this might create conflict with other sections that don't necessarily require that type of rulemaking that would get started right away or could get started right away. And so I do think that might create unintended consequences by perhaps not thinking through the timing elements, particularly when all of the rulemaking has to come before the legislature as a major substantive rule and be approved by this committee and the legislature as a whole.
Got
Which
it.
can't occur until the committee reconvenes again in the 133rd,
Second.
4th?
133rd, yes.
What are we on now? So the next one.
Yeah.
And then the last thing to look at are the unallocated language parts on Part D on page 20. So these are different than in the other proposal. So Part D, Section D1, and again, this is the thing that also made me really flag and think about timing, because this has a registrant being able to submit their results within 90 days of the effective date of this act for eligibility, but the programs for which you would be submitting essentially your eligibility won't be up and running for many more months, I would imagine, at a minimum. So I think that that's a technical conflict. Section D2 is the online trip tickets. So by July 1 of 2027, the Office of Cannabis Policy shall develop and implement an online trip ticket for registrants to use when transporting cannabis plants and harvested cannabis. And then D3 is the same language that was in LD 1840, I think, from
It was
last
18, it was LD
session.
1840, yeah.
So this, with the updated date, this language was included in that bill, which was enacted, but it was enacted at the beginning of this year, after January 9th of 2026, which was the current provision, and won't take effect until, I don't remember if it had an emergency, but I don't think it did. So 90 days after this session adjourns. And so this language is here, and it's directing OCP to provisionally adopt and submit for legislative review rules necessary to implement the medical cannabis research grant program, which is in Title 22, 2430, subsection 5.
And there is a bill in the legislature that's gonna make pretty much the exact same change. And so we'll make sure that the two dates match, just in case they both get enacted. So that will be changing even without this provision here. So
So
you
things
have,
to think about.
yes, you have directed those who are on this amendment and the stakeholders behind this amendment to discuss your questions. And we'll get you an answer as soon as possible. So you can continue
Okay,
with the work.
the third
you.
amendment is on Buff. This is the minority report put forward by Representative Supika. So my first question have to do with all the sections that are highlighted, but just real quick, did they show up on Buff and highlighted?
Yep.
Oh, good. Okay, mostly so when we made the motion, I got a lot of detail about your version of a testing program and tracking. And then the direction was to use the Mallon Amendment for large registered dispensaries, which is what I'm calling them. And I'm going to point that out in a second. But there are some other sections that were not related to testing or tracking. And I don't know if you want them in your amendment or not. And so I need you to tell me if you want them there. And they are, or if you want them amended in some way. And so I have highlighted those for you to take a look at. And we can go over them right now, or I can do the big overview and then we can come back.
I'm okay with going over them right
Okay.
now, if everybody's okay with them, or do we want to, yeah, because we got to go over
We
them
gotta do it,
eventually.
so.
So, yeah. But my understanding when I made the motion was it was just the dispensaries and then everything else wasn't going to be included. But that was my intent when I made the motion.
I'm not sure I'm
Yeah.
understanding what you're saying right now.
Okay. Well,
So I'm looking for the paper.
No, it's
need
okay.
to add my notes on it.
it was just the thing that I was taking from the majority report of the Mallon Amendment was just the testing and tracking and everything for the large dispensaries from that bill. And then everything else I wasn't.
Well, I would say these other changes are connected to
Okay.
those. And so it's up to you to decide if you
Okay.
want them or not want
Okay.
them. And I've kind of flagged, most of these are also flagged because they either were not included in the other amendment or were amended in some way, or just really were unclear on what you wanted to do with it. So
Okay.
section, we're going to do this first, then I'll go back and talk about what a large registered dispensary is. So on page 3. And it is section 11 highlighted, first one, 2423A, subsection 2, paragraph M. This is being repealed. This is the authorized conduct for a caregiver. And it is repealing the provision that allows an authorized, that allows a caregiver to conduct testing for anyone who's authorized to have cannabis for medical use, who, actually, I think it's just cannabis, but who asks the caregiver to do that testing for research and development purposes.
Could you repeat the first part? I got distracted by.
So this provision, and this is, most of these are in the beginning here are related to this, but under the authorized conduct for a caregiver, there is a provision that allows the caregiver to conduct testing for anyone who's authorized to have cannabis for the purpose of research and development. Do you want to allow a caregiver to still be able to conduct testing of cannabis on behalf of somebody else?
Yes.
Okay, so I will strike that section. You don't want to repeal it, you want to keep it. Section A14, 22, section 2423F. Subsection 4, paragraph D. This is the same language, but for manufacturing facilities, allowing them to conduct testing on behalf of anyone who asks them to for research and development.
It's a testing so are we talking like you go to the testing facility and they're paying like?
I don't know what this means in practice. The language says that a caregiver, a cannabis manufacturing facility, or in section A4 or A15.
I'd like to invite Gabby Berry Pierce because I imagine this originally possibly came from the office.
What I will say is that I can tell you how we are interpreting these provisions,
thank
if
you.
that's helpful.
Yeah.
So this would be testing not conducted by a cannabis testing facility, but instead by the individual registrant for research and development purposes. And so it would be having a caregiver, a dispensary, or a manufacturing facility have the capability to do their own testing and then provide those test results to the individual who is requesting those for research and development purposes. So
And this is by repealing this is saying it's okay to do that, or by repealing, this is where I feel like I'm in a double negative. land
yeah,
here.
so the language that is contemplated in the amendment right now that's highlighted, I believe came from LD 1847 and it was included in that bill as a cleanup to make clear that the cannabis testing facilities are the ones authorized to conduct testing, both for mandatory testing and for research and development purposes.
And that nobody else other than an authorized testing facility can conduct testing.
For research and development purposes or or for mandatory testing.
Okay,
So,
okay, gotcha. So it's just so that an authorized testing facility can do these types of, okay, I understand. What?
I don't want to say just for, I
Just an
want to say
authorized.
what is contemplated in the highlighted provisions would
Yeah.
be repeal
Yeah.
of a current authorization
Mhm.
for caregivers and manufacturing facilities and inherently hazardous substance manufacturing facilities that are currently permitted to conduct research and development testing in-house.
Okay.
Yeah.
And what was being proposed is repealing it so that they couldn't do it in-house.
On behalf of another person,
Oh.
for another person. They can do whatever they want for themselves.
Okay.
And as long as you're here. Can you just explain why you would repeal that authorization for research and development purposes only?
We would say that we would want individuals who are seeking out research and development testing to have reliable tests that are done with standards that are dictated by the various provisions in the Graham Amendment that require, looking at international standards for testing and that sort of thing.
Has there been any problem with the current state of affairs that you know of regarding an authorized, that authorized conduct being performed by someone on behalf of someone who requests it? Are you aware of any problems that have arisen from the current state of affairs?
I'm not, but again, we included it, or we recommended it be included in LD 104 and then in
Mhm.
1847 as a cleanup provision to make clear who has what authorized activities, because we have amended the medical statute many times and left things out. So we wanted to make we thought it would make it very clear who was responsible for what, but yeah, so but to answer your question, not that I know of, but that would not necessarily have percolated up to me.
Okay. I'll get you right in a second. I guess I'm trying to understand if there is, and this may be a question that gets answered between now and the next time we revisit this, but it feels as though if a patient asks their caregiver to test a couple of different strains to find something out about those strains because the patient feels that something is working or not, why would we prohibit the caregiver from being able to provide that service to their patient?
As I said, we would want, we think that the gold standard is having those standards in place so that everybody understands what it means to get a potency value or a value related to the level of particular microbes or, yeah, so those are the sorts of things that we would want there to be consistent standards for. This is not as I said, this is not something that has been a topic of much conversation or of much issues within the medical cannabis program. It was included as a cleanup provision.
There are caregivers who do extensive testing precisely for their patients, which currently is authorized in statute. So if this goes away, that particular service is no longer going to be able to be provided in that particular trusting arrangement. And I'm just saying that into the record because I didn't include those provisions in the Butter Amendment because I'm not exactly sure what the consequences would be for current practice. That's all. So I'm not sure that there's no good reason for repealing them. Did I say that wrong? It doesn't matter. I'm not sure it's just a cleanup, I guess is the point I'm trying to make. It might actually be something substantive for a certain relationship between a patient and their caregiver that we just haven't heard about because when we repeal a provision of law, it disappears, but there's not a lot of conversation about what we repealed and does it impact anyone negatively or not. So I just wanted to get your point of view on it. I've got it. I appreciate it. Thank you.
Yeah, and I appreciate you helping me understand that. I know, did you have a you could?
The chair recognizes Representative Boyd.
Thank you, Mr. Chair. Just outside the standards and statute and rule, can you talk about the oversight OCP does of the labs?
OCP or the state of Maine?
OCP.
The Office of Cannabis Policy, as outlined in rule and statute, licenses cannabis testing facilities, just like we license other license types. We then have a chemist who is on staff who reviews every test result that comes through, not only looking for anomalies related to the licensees who submit their cannabis for testing, but among the labs. And on I believe a biannual basis, she runs full reports that compare the labs to one another to make sure that we're not missing any anomalies. So.
Representative Speaker.
My question's for Ms. Olson.
Thank you.
So now how are these connected? You said a lot of these are connected.
Well, I think that as was stated, that there is still testing language. You are still changing testing. And so it was not clear to me at the time of the vote, because we didn't talk about it. Do you want to make these changes or not? As Senator Hickman said, his amendment does not have them.
No, I don't
The
want
Graham
to,
amendment does have them.
I don't want to make these changes.
Okay. Okay, go to page 6. This is that same provision for registered dispensaries, so you do not want to repeal it. You want it to stay.
This is,
It's
so
the same
this,
provision regarding testing for research and development, and this one is applicable to registered dispensaries.
then it stays if it's for registered dispensaries. Anything for registered?
Yes,
Yeah.
okay. Looking at page 7 at the top, these two provisions, section A23. This is a change that was made in Representative Graham's amendment regarding labels. And, sorry, I'm catching my own brain up to what I was actually going to ask you here. It wasn't clear to me if you wanted to make any changes to this section.
Could you repeat which, I apologize.
Yes,
A20,
page 7 of your amendment.
Uh-huh.
At the very top, section A23.
Okay.
It's actually, I've highlighted it and I'm asking you, do you want to remove this section from the amendment? Meaning you wouldn't make any of the proposed changes to this section?
Yes, it's removed.
regarding labels.
yes.
So if you are testing, and you were going to put a label on.
Yeah.
Do you want to remove this from the amendment? Or do you want to keep those changes?
This would only be applicable to anything that was being labeled and sold by and produced by a large dispensary, that they would put a label on it and sell it. And if that is practice that happens, but like, it wouldn't, other than that, no, it wouldn't.
Ms. Olson, did you say that these provisions that you are asking the chair about, are they in or not in the Mallon?
They're in the melon.
They are in the Mallon amendment.
Okay.
Because of the way the amendment was made, the motion was made,
Yep.
it was built upon the Mallon amendment. And anything that was specifically stated to be removed or changed or added was done. But there were sections where it was not clear when I went to draft it.
Okay.
What the intent of the sponsor was, or the person who made the motion was. And that is what I'm clearing up today.
Okay. So do you have an answer?
Yeah, for
Excellent.
large dispensaries.
So as current law, I'm just gonna get it up.
Mhm.
So current law, this is that labeling section. So if a registered caregiver, dispensary, or manufacturing facility affixes a label on the packaging of any harvested cannabis provided to a qualifying patient, and that label includes information about contaminants, the cannabinoid profile or potency of the harvested cannabis, the label must be verified by a cannabis testing facility. So that's current law.
Mhm.
Do you want to change current law?
No, I don't want to change current law. I don't want to change current law. I want to keep current law here the same. So, and this is changing, adding to current law. It's saying must include and shall affix. Like,
Yeah, so
Can
if
we,
you,
can we
yes.
just defer for 1 second? Committee will be at ease. Okay,
So I don't want to change the law here. I want to,
All right, so then I will remove the section from the amendment, not from
Yes.
law, from the amendment. Okay, the next section has to do with the cannabinoid potency. So this provision is in both of the other amendments, but it is different in those and I didn't know how you wanted to approach the potency. Where are you? Language. So if you were looking at the what you
Potency.
see here that I have
Yes.
crossed out is the language in the Mallon Amendment. If you were to look at the Hickman Amendment, you would see their proposed language at the top of page 6 for cannabinoid potency. I didn't know, this could be, you could use either version, you could tie, we're talking, this is again, 2429 C. So 2429C is packaging and labeling requirements. And it's establishing language about cannabinoid potency. For the purpose of packaging and labeling. And it's about essentially a variance rate.
I'm fine with not having it in here.
Okay, on page 18. This was in the Graham Mallon Amendment, patient education. It's a new provision about providing educational materials in addition to materials already required under 2429A subsection 4 to registrants at the time of sale.
Yeah.
Did you want to include that?
No.
All right, then. Part B, we didn't actually talk about adult use at the time of the vote.
Yeah, I didn't want to include any of that as well. Like any changes to adult use.
So, okay.
Yeah.
Does that mean you also don't want to make changes to the excise tax? If you do, you will at least need to add the definition of cannabis pre-roll. The changes to the adult use that are provided here are to align with the changes regarding mandatory testing that are still in your proposal for large registered dispensaries. That's the term I'm using, just so we're
Okay.
clear, for the 2,000 square feet registered dispensary. These changes for testing in section 602 are included in the Hickman Amendment with some exception. It also has the language in section 605 subsection 4 about additional further processing, manufacturing or alteration. That is, the language is also in 1488. The committee unanimously voted out. The use of the fund for research provision is not in Hickman's amendment, but is in the Mallon Amendment. So,
Ms. Olson, thank you for sharing that. I thought I read that into the record as being part of my amendment as well. For the
I'm sorry,
adult,
what do
for
you mean?
the uses of the fund for the adult use program. The money credited to the fund may be used to fund research on public health impacts of cannabis. And
Are you referring to section B12 in Supika's report?
yes,
You also want that in yours?
yes, I do believe when I read that into the record saying you can include that in my amendment as well,
I
because
do not have that in my notes, but I can add it.
I mean, I can go back and look at the tape, but I thought
Okay.
that.
What I do not have for your amendment, maximum batch size the language around subsequent processing, manufacturing, or alteration or
Yes.
use of the fund. Those were not included.
I think
in
use of
my
the fund
notes.
was the only thing that I read it to the record as being a part of this.
Okay, so you would like to add to your report the use of the fund.
The
in
adult
Section
use.
B12.
Yes,
On page 23 of Supika's amendment.
correct.
Are anyone on that report not okay with that or remembered it differently?
Representative Fredericks, I think, is the only other person who is here in the moment who's on that report. But I can go back and watch the tape. I'm pretty sure that I said, please
It was a
include that in mind as well.
confusing night. That's
Yep.
why we're doing what we're doing right now.
That's exactly
to
right.
Make sure that we didn't miss something in all of the proposals. And did you, I mean, I just said it, it's in this other bill, but did you also want section B11 about further no subsequent processing, manufacturing, or alteration?
That's being taken care of in a different vehicle, so. You just flagged for me that I
Yep.
didn't see that in my report, and I did want the public health money to be available from the adult use fund. for that
Great.
purpose, Yeah.
So Representative Supika.
Mhm.
Adult use.
Adult use.
At 20,
Mhm.
starting on page 20.
So the definition of cannabis pre-roll, like, I get that in there for, I'm trying to wrap my mind around, the definition of matrix and if that is in here just to kind of bring parity or if that would like.
Well, the changes. The testing programs are now more parallel between, as proposed in the bill, between medical and adult use, and it's establishing testing by matrix.
Mhm.
That's what's happening, beginning on page 21,
Mhm.
for the adult use program, is to add testing by matrix. And so that's why you have the definition of matrix.
Mhm.
So if you're, I guess, you only need to keep that if you also keep testing by matrix.
No, I don't want to make that change to the adult use program in
Okay,
this bill.
So you do not want to include sections B4 through B10?
Correct.
And that means we do not need matrix. The change in B3 for testing facility. This is made so that cannabis testing facilities, that term means both the ones approved for it in the adult use program and the ones approved in the medical use program. Do you want to include the language that was included in LD 1488 regarding subsequent processing, manufacturing, or alteration as an exception for additional
It
testing?
mirrors the language. Yeah,
It's the same as in
Yeah.
1488.
yeah.
So keep or remove.
We can leave it.
Do you want to use the same language or make the same changes regarding the use of the adult use, public health and safety and municipal opt-in fund?
That was the fund that was read into the record. Yes, I want to keep that.
Okay, those are all the changes that are in the adult use program. So we'll just be adding the definition of cannabis pre-roll, amending the definition of testing facility, keeping the language about further processing and manufacturing or alteration that is identical to the language in 1488. And keeping the additional use of funds from the adult use cannabis, public health and safety for research related to public health impacts, particularly on individuals under 21. It says money credited to the fund may be expended by the office to fund research on the public health impacts of cannabis use, including but not limited to cannabis use by individuals under 21 years of age.
Was that part of the fund that you,
Yeah.
that was part of the original, the one that was spoken of? Yeah.
Okay, and do you want to keep the changes to the excise tax?
Yes.
So we keep all of Part C. And then did you want to include any of the unallocated language that was proposed in the Mallon Amendment,
Part D?
Part D?
No. My memory was no to monthly reports. The section on the competitive bidding process,
It's probably not relevant.
yeah. And then estimate costs to develop and maintain, no. And then, yeah, no.
Now, the same this question, I do have the same question about an effective date that I had. I'm not sure. I can think about that.
Yeah, but
It is also major substantive rulemaking predominantly.
Mhm.
Although well, so that's actually a question. The Mallon Amendment for the provisions that direct rulemaking have routine technical rules. You did not address that at the time of the motion. On the sections that you are keeping that are the same for that report from the Mallon report. Did you want to keep the routine
Routine.
technical rulemaking? Did you
Yes.
want everything to be major substantive?
routine technical.
So we'll also, do you want a later effective date for the changes proposed in the bill? It is still requiring the testing program for large
Mhm.
registered dispensaries and does make changes to what is going to be tracked, the inventory tracking and what's submitted, and does establish a separate testing program. Those will take time.
January 1st, 2028.
That you can choose the date that you would like. The current provision is January 1st, 2027.
January 1st, 2028.
Okay.
Yeah.
Then let's talk about the substance of the changes now that we have the technical parts cleaned up and clarified. You wanted to keep much of what was for testing in the Mallon Amendment for registered dispensaries with over 2,000 square feet. In order to do that, I've established a new definition on page 2, large registered dispensary. This is a registered dispensary. It's defined in subsection 1 with a cultivation area, which is defined in subsection 17 of 2,000 square feet or more. This is for a cultivation area. A registered dispensary may only have one cultivation area. That includes mature and immature cannabis plants. I believe that those have to be separate, but in the same area. So this is by the cultivation area. It's not specific to plant canopy. If you wanted to go that route for plant canopy, we would need to specify that that's 2,000 square feet combined plant canopy of both mature and immature. So there's sort of two ways to go about defining that 2,000 square feet. And I wasn't actually sure which way you wanted to go. And so I'm sort of presenting one option and telling you that you could approach it by plant canopy. The definitions in statute specifically refer to mature and immature plant canopy. And so if you wanted that 2,000 square feet to be inclusive of both types, we'd have to specify that. Okay. There's a level of technical detail that I don't have to be able to kind of answer that for you.
I will get an answer to you today, very soon.
And And then subsequently made changes to section, well, this is where those A numbers start kind of becoming duplicative here, but A7 and A8, just to be clear. So there are sometimes when talking about a registered dispensary, we mean all registered dispensaries, regardless of their their cultivation size amounts. So registrant now has language saying including a large registered dispensary when referring to dispensary. So that when we talk about registrant and registrant agent, it's clear that we mean all dispensaries, regardless of their cultivation area size. Because we've added the new definition of large registered dispensary. And we want to make sure that it's clear where they're still included. So moving to page 7.
Chair recognizes Representative Fredericks with the question.
This is out of my wheelhouse dispensary. We have a license category for dispensary. And now we're going to define a large dispensary. Are we creating another level of the dispensary? Is that what would this definition?
We are not intending to create a new license type
Okay.
or registration type, sorry, in this case. Which is why it's not registered large dispensary. The intent is essentially to have created a carve out of a subset of registered dispensaries that have different rules for testing and tracking than other dispensaries
By way of size.
by way of
Yeah.
size.
Okay, I understand that. Thank you.
It goes back to kind of the concept that of market, like market share. Yeah.
In the same way as in the Hickman Amendment, on page 7 and continuing through the top of page 9, I have added to the registration violation types the sort of same penalty ladder language that corresponds with the testing program that is being enacted. So a major registration violation affecting public safety has the same language from the Hickman Amendment about intentionally or knowingly failing to conduct a recall of harvested cannabis or cannabis products when required to do so by the office. But then we have on page 8, under a major registration violation, exceeding the maximum level of allowable contamination for residual solvents or pesticides in a sample of harvested cannabis collected and tested under 2430U, subsection 4, paragraph B. 2430U is going to be the testing program that you outlined in your amendment. We'll look at that in a moment. And then under paragraph C on the top of 9, 3A has that language for a minor registration violation. And it's earlier in that testing process for that one. Continuing on page 9, same process for section 2430J about records, reporting and tracking of inventory. So that again is being repealed and replaced. So the first paragraph is the same as in current statute, except that it is exempting large registered dispensaries. Large registered dispensaries are subject to that second paragraph, that the office shall also implement and administer a statewide inventory tracking system through which large registered dispensaries are required to submit to the office electronic records required pursuant to the chapter. And that those dispensaries should pay all fees and costs associated with that. They both have the confidentiality provisions for qualifying patients and medical providers. Subsection 1 is applicable to all registrants other than a large registered dispensary. This language is the language that was presented. Well, it's a rework of the language that was presented about what types of records these individuals will have to keep. So again, like with the Hickman Amendment, for those who worked on the language proposed at the time of the motion to carefully examine particularly this section and subsection around required records. So are intended to be specific to the type of authorized activity being conducted. Disclose all authorized conduct and all transactions of the registrant in enough detail for the office to be able to conduct an audit for compliance. Are inclusive of the time period from purchase or acquisition of cannabis plants and harvesting cannabis through any manufacture, transfer, sale, or transport of the cannabis plants or harvested cannabis. Can be used to trace the cannabis plants and harvested cannabis back to the registrant where those originated from. Documentation of the batch number on any cannabis plants and harvested cannabis received or the batch number assigned by the registrant to any cannabis plants or harvested cannabis cultivated, harvested, or manufactured by the registrant. Any documentation for any batch numbers that are for newly created batches. Sufficient detail to be able to conduct a recall. So those are the types of information that would need to be retained. Those are not. I don't know what all of those would look like. But they have to keep the records for a period of 4 years and make their records available for inspection by the office upon the office's request. B and C are similar to current law. Subsection 2 is specific for a large registered dispensary. And would mirror the Mallon Amendment. The subsection 3 required label is not changed from current law. The rules for this, well, again, that's not changed, so it's just specific to required labels. And then subsection 4 is specific for large registered dispensaries, and it's the language about inventory tracking that is in the Mallon Amendment. So then there's the office can adopt rules to implement the entire section. I don't actually know if that works here. Because it does rules regarding the process and content of records to be submitted and the frequency with which records must be submitted, as well as rules regarding the inventory tracking requirements. It may, so there is some contradiction. Some of the subsections have major substantive rulemaking, but this paragraph allows for the entire section to be routine technical. So that could create some conflict in the rulemaking process. I don't know how, if you want to, I can just pull out, I can get rid of the overarching one and create separate rulemaking sections, language for each subsection.
That would be best.
If I was to do that, is the intent for inventory tracking, subsection 4 for large registered dispensaries to be routine technical as was proposed in the Mallon Amendment?
Routine technical for that is fine.
So labels would remain major substantive.
Routine technical.
Change all to routine technical. For
Is
the-
that, that's all under the, for the large like?
No,
no.
we're,
That would be-
required labels would be just for registrants other than large registered dispensaries. And other than that exception, that's current law. It doesn't look like it because I had to repeal the section, but required label is in statute right now for all registrants. This change exempts large registered dispensaries, so
Yeah.
they would not have to have the label because they're gonna have the tracking information
Okay,
in the inventory tracking system.
so what is your question here? I apologize, that's on me.
sorry,
Like, No,
there's-
sorry, that's
no,
on me.
It's okay. This is just about rulemaking authority.
Yeah.
Because I just duplicated current law for subsection 3, there is a rulemaking provision for the required label. Those rules are major substantive for the label. The changes proposed in the Mallon Amendment, which you can see in subsection 4, which now only apply in your amendment to large registered dispensaries. There was language in that section that made all of the inventory tracking routine technical rules, which kind of contradicts with current law. So I need you to sort of direct me about how and what rules you want to be major substantive or routine technical, since, well, you don't have to break them all up. You can say all of the rules for this section on record keeping, reporting, labels, and inventory tracking are one type of rulemaking or the other. Or you can be more specific and say for the things that apply to registrants other than large dispensaries are one type of rule, and the things that apply to large registered dispensaries are a different type of rule.
So large registered dispensaries can be routine technical, and then everything else under current law as it is major substantive.
Well, you do amend what is currently required for everyone else. That's changed from current law. So, but you would like those to be major substantive. Page 11, section 826. This is current law, section 2430K. This is the language about inspections as well as limitations on inspections. So I've made a couple of changes here. So currently the law says that the office may conduct inspections. And so we've added a provision at the start that says the office shall conduct annual inspections for everybody other than a large registered dispensary. And then may conduct the other types as they currently do. And then because we're changing the entire section, correcting department to office, that's a technical thing. And then adding language in subsection 2A regarding the annual inspection, sample collection, and mandatory testing, providing that during the annual inspection for registered caregivers, registered dispensaries other than large registered dispensaries and manufacturing facilities, the office shall collect a sample of harvested cannabis located on the premises where that registrant is conducting activity authorized under the chapter, and that the office will conduct testing on the sample in accordance with section 2430U. So that's the sort of authorization for the inspection and the collection of the sample for testing. And then at the bottom of this page 12, in section 826, this is the language specific for large registered dispensaries. This is the testing language that's in the Mallon Amendment, except now it only applies to large registered dispensaries. And then I'll just note then we have the mandatory, the sample testing program on page 18. So this establishes outlines the annual inspections and mandatory sample testing for 2430U. Again, closely examine this. We did discuss your proposed amendment the night that the motion was made, but this is a fleshed out version of statutory language to hopefully accomplish those goals, but should be examined closely. So the office would conduct testing of samples collected during the annual inspection for registered caregivers, dispensaries other than large registered dispensaries and manufacturing facilities. It does add that nothing in this section may be construed to limit the authority of the office to take samples of harvested cannabis pursuant to an investigation by the office into the conduct of a registrant or a registrant's agent. So this would not be the only time that you could be inspected. But it's meant to maintain the current authority that OCP has to conduct inspections, but to now require one annual inspection at which the office will collect and test a sample of harvested cannabis collected under the section. That test is for residual solvents, metals, molds and mildew and pesticides. I did not bring over the full language for mold and mildew. I don't know if I needed to or not. So it's just the abbreviated version that was what was stated on the record at the time of the motion. And then the costs of conducting the tests under the section are paid by the applicable registrant. That the office may conduct other tests on a sample of harvested cannabis collected under the section for the purpose of research and data collection, but that those tests would be paid for by the office. A requirement that the office would notify a registered caregiver dispensary other than the large registered dispensary manufacturing facility within 1 day of the office receiving the results of any test conducted under the section. And that the office would provide a written copy of any test with that notification. And that the registrant is required to keep all test results from under this section for a period of 4 years in the same manner as other records required to be kept under the chapter. Subsection 4 outlines the sort of what happens if provision, as well sort of the steps. So if a test conducted under the section for residual solvents or pesticides indicates that the sample exceeds the maximum level of allowable contamination, which is determined by the office pursuant to 2423G and those rules adopted by the office. Those are the rulemaking for the mandatory testing for now in this amendment, large registered dispensaries. The office would provide notification as required under subsection 3, so within 1 business day in writing. Or with the written results, and if applicable, to provide notice to any registered caregiver, registered dispensary, this could be of any size, or manufacturing facility from which the harvested cannabis sample originated, to then collect up to 3 additional samples of harvested cannabis from the registrant whose sample exceeded the maximum level of allowable contamination. And from any registrant from which the harvested cannabis sample originated. And from any location where authorized conduct is being done. So if they had more than 1 cultivation area, if they had a cultivation area in a retail store, or so forth, it could come from any of those places, not just where the original sample was collected. Shall restrict the transfer or sale of the batch of harvested cannabis that exceeded the allowable contamination level under the subsection, and may initiate a recall that of any that has already been sold or transferred from that batch. And then shall conduct additional testing for residual solvents and pesticides on the additional samples collected under paragraph B at the expense of the registrant. And then if additional testing under D indicates that any of the samples collected exceed the maximum level of allowable contamination for residual solvents and pesticides, the office shall restrict the transfer or sale of all batches of harvested cannabis in the possession of the registrant, initiate a recall on any harvested cannabis sold or transferred by the registrant from the batch or batches of harvested cannabis tested, and shall open an investigation into the conduct of the registrant. Subsection 5 outlines the results if you exceed that maximum level. So the following administrative penalties might apply. If your initial test under the section indicates that your harvested cannabis exceeds the maximum level, you may be subject to an administrative penalty for a minor registration violation. So this corresponds with the change in I. And then B is for everybody, which could include also a large registered dispensary if they were the ones who had originated the sample. If a sample collected under that further collection exceeds the maximum level allowable, it may be a major registration violation. And then if the office opens an investigation into the conduct of a registered caregiver, registered dispensary, or manufacturing facility, evidence of a violation of this chapter or rule adopted pursuant to the chapter would be handled pursuant to 2430I, which is the inspections, compliance, violations, and penalties section. So again, I would ask that those who supported that amendment and worked on it with members of the committee kind of closely examine both that and the required record keeping section that were significantly, in this case, not rewritten, but written based off of what was orally described at the time of the motion.
Yeah, the inspections, testing, and the penalties sounds like what I wanted and tried to speak into the record that evening. I will get back to you if I need a moment to clarify in my mind the sizing of the difference between like the canopy or the space. And then there was another section that I had a note here to look at further record keeping requirements. And so far that looks like what was intended as well. So like that looks good. So it's just the only thing that I'll look into is the only thing that I have a question on is the canopy versus the space size. Yeah. Thank you very much.
Are there any other questions about this proposed amendment from representatives of people that the meeting has? Chair recognizes Dr. Fredericks.
Thank you, Mr. Chair. Just the record keeping, I think was suggesting 6 years. Is that?
4.
Okay, thank you very much.
So we're at 10 minutes after 3. I know there are stakeholders here. I was thinking that we would just go at these for a few minutes so folks can discuss amongst themselves and with whoever is sponsoring their supported amendments, if they have any answers to any questions that we can get for you before we adjourn today. And if we can't get those answers, we'll come back and adjourn, and then we'll get those answers to you as soon as possible. So for now, the committee will be at ease. Committee will be in order. The committee will be in order. Welcome back to the Joint Standing Committee on Veterans and Legal Affairs. So just having spoken with Ms. Olson, what we're going to do is we'll adjourn for the day, and we will make sure that all the stakeholders who are part of any or all of these amendments can get all of the answers to Ms. Olson or the chairs simultaneously on Friday. Before we meet again on Friday, we are scheduled to meet this Friday to see what else we have to report out and to also come back to these because these are first drafts. And again, we'd like to thank Ms. Olson for all of the time and attention to translating our ideas and thoughts into this language that is in front of us in all three of these amendments. It's like 3 bills in one. So we really do appreciate all the work and time that it takes to make this happen. And so we'll come back to this on Friday. Any other issues that you would like for us to think about between now and Friday, Ms. Olson? We will be meeting at 9.
That is correct. We are meeting at 9 o'clock on Friday. We are opening with the report from the Maine Veterans Homes, their annual report. So that is at 9 o'clock on Friday. We cannot start unless we have an in-person quorum.
Correct.
And then anything else that I have to bring back to you, I will have, but we are probably reaching a drier spell.
Yeah.
So,
So if people know now or tomorrow, you cannot be here at 9 o'clock on Friday morning, please let the chairs know. So that we can make adjustments as necessary. But the Maine Veterans Homes, they are coming to present their annual report. We know that's a really important issue for our veterans. And so I would expect that we will just all be here as close to 9 on Friday as possible.
Chair.
Representative Boyd.
Would it be appropriate if maybe we scheduled the report for 10 a.m.?
The report is for 9.
All right, I'll be here.
The report is for 9. That's on purpose. The report is for 9. And what we do after that is what we do after that. And who's here is who's here, but we can't begin a meeting without a quorum. So in-person quorum, not online, in person. Any thoughts, questions, or concerns? Seeing none without objection.